Hello, everyone. Welcome to our second conversation in a series of short chats that partners at CMRE are having in relation to the issue of client confidentiality and data protection. You may have watched our first conversation about this that related to relevant considerations around lateral hires and team moves. This conversation is going to look at the issue, the similar issue from the aspect of transactions in relation to law firms. I'm Nick Leale. I'm a regulatory partner within the CMRE team, and I'm with Corinne Staves, who's an expert in partnership and has advised firms in relation to numerous mergers, acquisitions, and other transactions over the years. So first of all, Corinne, what do we mean when we say we're discussing the issue of transactions?
Well, it's a great question, Nick, and I think that it's changed a lot quite recently. Previously, maybe last year and before, you'd largely been thinking about mergers between two law firms, for example, and of course we're still seeing that. But now we're also considering transactions in the context of people investing, and I'm thinking specifically about the wave of private equity investment we're seeing into legal services at the moment. So really, we're talking about any kind of acquisition or merger or business transfer, and that could be in a context where a business is in distress. It could be in a context where it's to drive growth. It could be as a really strategic move, as I say, maybe PE backed, sort of drive the next phase of the business's strategy. So it could mean a number of things, but at its absolute core, it's that something's happening with the business. There's a business transfer or there's a share sale where sort of two parties are involved in discussions and hoping to achieve a combined effect.
Yes, thank you. But of course, when we're dealing with confidentiality and disclosure, it's one very specific part of the Code of Conduct for solicitors and the Code of Conduct for firms that we're interested in the Code of Conduct for solicitors. It's paragraph 6.3, of course, which requires all solicitors to keep the affairs of current and former clients confidential unless that disclosure is required or permitted by law or the client consents. And that's at the core of the discussion, and it's relevant right from the start of any kind of discussion about a transaction, isn't it?
Yeah, I mean, it absolutely is, and as you point out, Nick, it's incredibly restrictive. It's keep client information confidential. So if you think about the very start of any transaction, there's going to be a couple of parties getting together, chatting through heads of terms, and things in a law firm context like conflicts, like clients, like strategic opportunity are going to come up really early on in heads of terms. But the restriction that Nick's just summarised there makes it really hard for law firms to actually have open conversations, for example, about their clients, about potential conflict situations, about the type of areas where they're looking to grow. Obviously, it is possible to do that in sort of strategic terms, looking at sectors, the types of clients they might be working with. But unless it's sort of publicly disclosed, for example, a litigation practice where you're sort of a solicitor on the record, really difficult to be able to disclose that information. You then think about the next stage of the transaction. So you get through to the due diligence stage. Maybe you've managed to agree heads of terms, generally speaking. Then you're going to really want to get under the bonnet of the respective businesses. And that's going to be hard too, because if, for example, you wanted to do file audits on sort of the risk management or the AML aspects of the business, how can you do that without sharing that client's name? How can you check conflicts to check that, large parts of the business aren't going to clash with each other? Is quite constraining in practice, and of course you're not going to have express client consent, because at that stage it's still going to be incredibly confidential, the fact that there are merger discussions or acquisition discussions underway. And
it's an issue that's come to the fore in recent months, as no doubt a number of viewers of this will be aware. The SRA have been taking more frequent action against individuals who, perhaps in a different context, have been guilty of passing on client confidential information in similar sort of circumstances, and it's actually led to Section 43 orders and various kind of rebukes and fines of individuals within the profession. I just want to be absolutely clear about this. There's no way round that part of the Code of Conduct in the early stages of any transaction, or is there though, Corinne, a way as matters progress that a firm might be able to exchange a level of information in relation to clients.
Well, I mean, as we've discussed, Nick, the client consent is the sort of the solution here, which isn't necessarily practical in terms of giving people options on how to manage this. But it is really clear how seriously the SRA take all this. As you know, Nick, they've produced back in 2024 a warning notice on mergers and acquisitions, where they specifically highlighted the risks around to the compliance with the code around confidential information. They talked about thinking about client files. They talked about seeking client consent, those sorts of things. So it is clearly on the SRA's radar as an area where there are risks, and confidential information is one part of it. We talked in another podcast on that M&A warning notice about the other risks that they're quite focused on. And I think we could probably speculate that that's going to get more and more focus rather than less and less focus in the wake of Axiom Ints and SSB. And we certainly know that the SRA is kind of probably likely to consult next year on the measures that it's going to take to implement the Legal Service Board's recommendations that it needs to do more, frankly, in respect of mergers. So I don't think we're going to see an easing of the obligations that are already in place, but it will be interesting to see if they're more sophisticated to reflect sort of the commercial realities of these sorts of deals. I don't know whether you think that's likely or possible, really.
What is clear is that in the years ahead, the SRA are going to be much more involved in all acquisitions, aren't they? There's that expectation placed upon them, and they will, in order to respond to that, given all that's gone on, they're likely to take that very seriously and make their involvement substantial. I think we have to assume that, and that will mean that firms will no doubt meet with people from the SRA through the process from a relatively early stage, and will be asked a number of questions about how they've gone about the transaction, how they've gone about exchange of information, which is why this is probably going to come even more to the fore as it becomes clear how the SRA are going to approach it all.
I completely agree, Nick. And I think that exchanging information, as we've talked about, sort of at the start of the transactions, as the transaction evolves, is one thing. And I think it become even more acute, as I say, with more and more PE activity in the sector, because law firms understand their regulatory obligations and confidentiality and those sort of professional obligations run through us. But bring in someone from an external sector, I'm not saying that PE is bad. I'm just saying they're not lawyers. So there needs to be education there about the rules that we are subject to, and just how important they are to us as regulated firms and regulated individuals. But then if you think towards the end of the transaction, sort of a completion, then what's happening there? Well, either there's going to be another owner who's part of the business in a PE type context, or perhaps there's a group structure put on top of the existing law firm, or in a merger type scenario, you're actually going to see a transfer of files of client information. So there, client consent is going to be really important in original documents, and we've talked before about the risks around who's looking after these files from a best interest of the client's perspective. But there's confidentiality risks there, and we've seen fines, haven't we, where information has been sort of treated like an asset, really, and client files have been transferred, and quite substantial fines have been issued both on the party, the law firm that transfers the information without client consent, but also on the party that receives it because they're in full knowledge of the fact that client consent wasn't in place when those assets were transferred, to describe it in the way that the criticism was levelled. Obviously, these are client files. Client consent is needed for that transfer of confidential information. So it sort of runs all the way through, and there can be a hangover into sort of the integration period, obviously, because in a distressed situation, you can see that perhaps it won't be possible to get client consent for everything, which is still a technical breach. But I think it's quite pragmatic for firms to think that that's a better outcome for the clients and the client files in those scenarios. But then you've got a lot of unravelling to do after the event, seeking retrospective client consent and those sorts of things. And there's probably an obligation to report, I'd have thought there, Nick, wouldn't you?
Yes, and it's a difficult situation, isn't it? Because the SRA are also very keen to emphasise that clients must have choice, and they must have time to make choice, and that therefore makes it really insufficient to just announce a merger very, very close to the date and state that client files are automatically moving across to the new entity, because that's just not that's just not sufficient. It doesn't provide choice. It potentially generates accusations that the client's being treated as a commodity, and trying to get the balance right there, and giving time, most importantly, for the firm to ensure that clients have consented and had an opportunity to consider the position is really, really important. Is there a way, though, potentially of mitigating the situation, or at least giving the firm some freedom to exchange client information any way through, for example, letters of engagement or terms of business when clients are engaged?
I think you've hit the nail on the head there. I think it would be really sensible for firms in their terms of engagement or terms of business, however they communicate with clients and provide information to clients at the outset, to sort of have provisions which makes it clear to clients that their information might be disclosed in those sorts of circumstances, and in effect seeks consent from them. Now, obviously, law firms always need to be careful about sort of hiding things in the small print, and you always have to think about whether that's actually sort of truly informed consent. But frankly, if you don't have it and you want it, you're going to be stuck. Much better to have those terms in place and to have those protections, and then to think about it when the issue is live. So I would absolutely recommend that firms think about including provisions in their terms of business that on the face of it would appear to permit disclosure of information in a certain number of circumstances, obviously whilst thinking about the client's interests, just so that there's a bit more flex there if they think it's appropriate at the time.
And that will at least, hopefully, allow firms to exchange information in relation to who they act for, if none of the detail. I mean, that could never act as a green light to exchange substantial information or particularly sensitive information, but it may be enough in order to at least enable things to progress satisfactorily and within the code of conduct at the start, and as the matter progresses, before the transaction is going to complete, and then proper consent to move the client to the new entity is obtained.
I would stress again that it's going to be a case of looking at the circumstances in the time, what's happening, what's the information, how does the regulatory obligation sort of superimpose itself over that information. So firms are going to have to think of it as in each live case. But I absolutely agree that would put firms in a stronger position, perhaps with a bit more flex, because it would be in everybody's interests, especially clients, to make sure that people can manage transactions carefully and with careful thinking and real prioritization of clients and their needs. So yeah, I think it is a good idea to put that in the terms of business so that clients understand the potential actions firms might be taking.
And have this issue in mind from the start and throughout the process, and have in mind how the requirements and the expectations of exchange of information with clients grows as matters progress towards completion.
Exactly.
Well, no doubt we will, or you in particular, through the work that you do, Corinne, will see in the months ahead how the SRA's approach may be adapting to all that has gone on in anticipation of specifically what they intend to do on the basis of the ruling made against them by the Legal Services Board as a result of Axiom and SSB, and you'll be the first to see how the attitude is changing and how the approach is changing, no doubt.
Yeah, let's hope so. We'll watch this space, right? 2026 is going to be an interesting year from the SRA perspective, isn't it?
Indeed. Okay, well, thank you very much. It's been a very interesting discussion. I hope you've enjoyed watching it, and we look forward to seeing you again soon.
Thanks so much.